All right, guys, today on You've Got Questions, I've Got Answers. It's going to be a fun one. The question is, what do I legally have to disclose as a Florida home seller? Stay tuned.
You better get fired up.
Guys, great seeing you. Happy Friday. We're here every single Friday on You've Got Questions, I've Got Answers at 11 o'clock, where we answer your biggest questions in real estate. This week, we're going to talk about what you're legally responsible for disclosing as a home seller. And I think this is important not only for home sellers to know, but also for home buyers. Legally, you are responsible as a seller for disclosing anything that affects the value of the property that is not easily observable, right? So what does that include? What does that not include? It includes a roof leak that you know is going on. You can't see any wetness on the ceiling or anything like that, or maybe you can, but it's not easy to see, right? It's just a little bit of discoloration, and the common person might miss that. Maybe you've got radon gas, you know you had it, or you've got lead-based paint on your walls, or you've got some sort of mold infestation up in the attic. These are things that can't be seen by the typical person, but you know they're there. And if a buyer knew about them, it would negatively impact the value of the property. Those have to be disclosed. What doesn't have to be disclosed are things that A, don't impact the value, and B, are readily observable. So if you've got, let's go with the readily observable first. If you've got a broken window, you don't have to disclose that. If you've got tore carpet, right? You got a tear in your carpet, you don't have to disclose that. That's easy to see. And if you've got things that don't impact the value of the property, for example, you had a roof leak, but you fixed the roof leak and now the roof is in great condition. It's been there for 2 years. You haven't had any leaks since. You don't have to disclose that legally, right? You could, but you don't have to. So that's the legal answer. The questions you're asking yourself is, does it impact value, and is it easy to see, right? If it impacts the value, you can't see it, you got to disclose it. So let's go to the next question. Joe, I'm an investor. I've never stepped foot in the property, or it was my mom's house and I never visited her. I've never even been inside the property. My mom passed away. Or it was a secondary property that I owned for 15 years, but honestly, we haven't even used it in the last 3 years. Or it was a rental and I've had tenants in there, but other than what the tenants have told me, I've never even seen the property, never been in it. I don't really know anything about it. Do you have to fill out property disclosures? So in Florida, you don't have to legally fill out property disclosures, but not filling them out does not release you from your responsibility to disclose anything that affects the property's value and isn't easily seen by the eye, right? So if you know about something and the buyer can prove it after closing, they can come after you for it legally, right? Even if you didn't fill out those disclosures, even if you were a landlord, even if you were an investor, even if you inherited the property from mom or dad after they passed and you'd never been in the property before, you can still be sued if they can prove that you knew about the issue and you didn't disclose it to them. Now, that's a challenging thing to do, but if they could, then you absolutely would. So a lot of agents, listing agents, and this is due sometimes to brokerage policy, we'll say, hey, we don't have any property disclosures on this because the owner is an investor. Okay, well, because they're an investor doesn't mean that they don't fill out disclosures. I understand that the implied intent is that because they're an investor, they've never been in it, they don't feel the need to fill it out. That's another thing. But do they legally have to fill it out? No. But are they still responsible for anything if we find out about them and they didn't fill out disclosures? Absolutely. So I want to put that little myth to rest, right? So what is my personal recommendation on this? Should you disclose? Shouldn't you disclose? I always say this, when you're reading through disclosures, if you're going to disclose things, which obviously you need to follow the law, right? I also think as a investor or someone who's never been in the home, fill out the disclosures. When you don't fill them out, for some of my clients, especially if they don't do a lot of real estate, or they're just, a really analytical person, or they're high anxiety, not having those disclosures is going to make them nervous. And a lot of people won't move forward without them. Why would you risk losing those buyers when all you're going to say to all the questions of, are you aware of, is no, I'm not aware of any of this stuff because I didn't live there. So you can't list anything negative anyway. So why not fill them out, right? And you're held to the same standard whether you fill them out or not. Either way, in the court of law, if you get sued, because that's what you're concerned about, you're going to be responsible for anything they can prove that you knew before you filled out the disclosures or sold your house, whether you filled out the disclosures or not. So for me, I think it's a great thing for you as a home seller to fill those disclosures out and fill them out honestly. Now, there is a section at the bottom or there's a part at the bottom of each little section. I don't remember how many sections they've got, maybe 8 or 10 different sections. And one will focus on maybe electrical, and the next one will focus on plumbing, and the next one will focus on the roof. And you go through and answer all these questions. If you have a negative response to any one of these questions, you have a section at the bottom or a part of the bottom of each section that allows you to describe what the issue was. And you can put a little PR pitch in there, right? And say, hey, we had a roof leak. It was in 2019. We got it fixed by ABC Contractor. We got X warranty on it. We've provided the warranty attached with the disclosures. The new buyer will take over that warranty, and we haven't had any issues since that repair was done. Wow, okay, well, as a buyer, I feel pretty good about that. Most roofs have a leak at some point. It's not untypical, and to get it fixed, well, that's what I would have wanted you to do. You told me who the contractor was. You've got a warranty. You told me I'm going to be a part of the warranty once I buy it, and it was 6 years ago, and you haven't had any issues since. To me, that's pretty cozy and comforting. And there's the added benefit of, I just feel like you're being honest with me now because you didn't have to disclose that, and you did. So it makes me feel good. And now I trust the rest of the disclosures. So for me, if you've got something that you fixed and it looks really good, if you show them that you fixed it and it's taken care of, especially if you've got a warranty, why not put one of those things on the disclosures, right? Do you legally have to? No, because it doesn't negatively impact the value of the property. But to do so, I think, buys a little goodwill with that buyer. So, we can argue about it either way, but for me, I've really never seen an issue with it as long as the thing has been repaired. I have seen situations before, both as the agent that is representing the client and as the agent who represents the other client, where it's obvious the seller knows something and they don't want to disclose it. If I know about it and I'm representing you, I'm the listing agent, you have to disclose. I have to tell you to disclose it. And if you don't, it's my duty to disclose it, right? We've got to disclose it. It's not like a lawyer client privilege where you can tell me you murdered the guy and we can keep it secret. Like, I can't do that. I can keep a lot of things secret, right? The fact that you're listed at 500, but you would take 480, I can keep that secret. The fact that you don't want the other person to know this, but man, would you like to close in 20 days instead of 60 days? I can keep that secret. All these different, the fact that you're going through a divorce, so you're highly motivated, I can keep that secret if you'd like. I can keep all those things secret. But when it comes to you disclosing things that legally have to be, or not disclosing things that legally have to be disclosed, once I know about it, it has to be disclosed. Now, here's another mistake that I see a lot of different realtors make, at least in my opinion, is when I'm the list agent. I just had this happen. And, well, let's say this. I'm the buyer's agent. And we come in and we get an inspection done. And I know my buyers aren't going to move forward. They're not going to move forward. Whatever's going on, it's too much for them. And they just said, hey, we're not going to do it. I'm thinking, in the benefit of the seller and the listing agent, I don't want to share that inspection. Because if I share that inspection with 27 different issues on it, which even in a beautiful house, you're going to have 20, 30 issues on it. You're now responsible for disclosing all those issues if they're not readily seen, which a lot of them aren't, and they negatively impact the value of the property, which almost every single one of them does. Do you want to be in that position as a seller, as a listing agent, to have to disclose all that? No. And a lot of them won't disclose it. They'll see it and then they won't disclose it. And then what happens is buyer 2 comes, buys the property. None of that stuff was disclosed. And then all of a sudden agents start talking because it's a small world. Oh, we were under contract on that one. We walked. I sent the, what do you call it? Inspection to the list agent. Did they show it to you? No, they didn't tell me about an inspection. Well, now it's closed. So guess what? There could be a lawsuit from that next buyer, buyer number 2, against that seller because they knew about all those things and they didn't disclose it. So my recommendation to my sellers is we don't ever want to see an inspection report. Ever. There's caveats to that. But even if I do want to see the inspection report, I don't want to see the whole thing. I want to see the little cutout of what it is I'm interested in, right? So if there's a roof leak and I'm thinking, okay, I got to be able to tell the guy who's fixing it where the roof leak is. Can I get the photo? I'm specifically going to say to that buyer's agent, can I get just that one section of the inspection? I don't want the whole inspection. Would you mind sending that to me in a one-page PDF? Now I'm responsible for that one little section. If I ask for the whole report, we're responsible for disclosing that if that particular buyer falls apart for whatever reason. I don't want that. But I do see a lot of list agents saying, out of like frustration, I want to see that report. And I think, do you? Because now you're responsible for something and you're probably not going to disclose it. And now you could get sued. Your client could. So just remember that that's another responsibility you bear when you ask to see that report. All right, guys, hopefully that answers all your questions when it comes to disclosure here in Florida. If you've got more questions or there's anything I missed that you've got questions on, please feel free to put in the comments below, or you can send me a private DM on Facebook and I'll always answer them. If you've got future questions for You've Got Questions, I've Got Answers, again, leave them in the comments or send me a DM and I'm happy to answer them. Guys, thanks for joining me and have an absolutely beautiful Friday. Have a great weekend.